Good morning, Jennifer.
Good morning, Izzy. How are you?
Good, it's Friday.
Yes.
I hope you have a nice weekend. I'll see you later.
See you later.
playing their intro music,
Oh.
so no. But if you want
I'm
to
off.
turn your camera off,
No, I'm good.
unless you want, okay, cool. So I'm literally watching you right now.
Good. Yeah, well. Let's put this up a little bit more so I can see what.
We can hear what you're listening to, Mark.
I'm not listening to anything.
In my courtroom, you'll be treated fairly and with.
Sounds like a
I respectfully ask for your vote for judge.
political ad.
Ah, maybe that's the background that's being aired on the web feed that Jennifer's listening to. I don't know. Now it's not letting me sign into my Clio for some reason. Guess what I do is turn this off, turn that off, turn that off. I don't know what this is.
Court will take this matter under submission.
This is the time set for your hearing on custody.
Hello, council. Is there anyone that should be on that you don't see on as a panelist?
This is Mark Thurman. I only see Miss Jones and I and you is as video. The rest I just see is names. And it also says CC Department 7. I thought we were in Department 8, but I don't know.
We are. It's just another court clerk observing. So we're okay. Just I'm just concerned. I don't want to miss any other attorneys or any other parties that need to be involved within the
Well, I
hearing.
got 2 more coming, dropped in. So the director's conference room and Craig Ott are on. And then I see Izzy missing, and I don't know who else we're missing.
Defendants believe needs to be on is added.
Okay, thank you.
Apologies, Madam Clerk. I know Jason Guanasso is not in. I don't know if he's joining us or he's supposed to be added or not.
I do see him. Who is he? I'm sorry.
He's the special master.
Okay, thank you. Okay, he should be joining us shortly. Looks like he might have gotten disconnected when I tried to promote him, so we'll see. I'll keep an eye out for him. Thank you. We're just waiting on Jason to reconnect and then we can get started. He got lost when I tried to promote him. Has anyone heard from Jason? He hasn't reconnected.
I heard that he was attempting to reconnect.
Well, this is Miss Jones. I'll text him.
Thank you very much. Hi, Council. We will begin at 11:15, even if Special Master Ganazo is not able to connect.
Thank you. I haven't received a text back, but if I do, I will let you all know.
Thank you.
Okay, good morning, everyone. Sorry for the slight delay. We're on the record in the case of Payne versus Detr, Civil 20-00755. I'm Judge Breslow, presiding judge in Department 8 of Nevada 2nd Judicial District Court. The now familiar preamble, we are proceeding through simultaneous audiovisual means as allowed by Nevada Supreme Court Rule Subpart 9, administrative orders of the 2nd Judicial District Court and the Nevada Supreme Court. I'm joined by the court reporter, Ms. Izzy Zinn. Ms. Zinn, good morning. Where are you calling in from, please?
Washoe County, Nevada.
Thank you very much. The court clerk, Ms. Encolado. Ms. Encolado, where are you calling in from, please?
Washoe County, Nevada.
Thank you very much. Counsel for plaintiff, Ms. Jones, good morning. Would you please identify yourself and also what county and state you're calling in from?
Good morning, Your Honor. Leah L. Jones calling from Washoe County, Nevada for plaintiffs.
Thank you. Mr. Thierman.
Yeah, Mark Thierman for plaintiffs also, and also from Washoe County.
Thank you. Mr. Ott.
Thank you, Your Honor. Greg Ott calling in from Carson City, Nevada, also joined by Troy Jordan and Administrator Gott.
Thank you. And good morning, Administrator. And then the court's special master, Mr. Guanasso.
Yes, good morning, Your Honor. Calling in from Lane County, Oregon. Thank you.
Very good. Thank you. Welcome, everyone. All right, let's get right to it. The court asked for this hearing on relatively short notice because I want each side's response to the singular question of whether the recent appeal by plaintiffs divests the court of jurisdiction for some or all parts of this case. And then now, in light of the cross appeal by the state, same question, whether that in combination or alone would change this court's ability to preside over pending matters. Let me hear first from Mr. Thierman or Ms. Jones.
Yes, good morning, Your Honor. The Nevada system is somewhat different than the federal system in that the denial of an injunction or the denial of a writ is an appealable as of right as opposed to discretionary. But having said that, it's only an interlocutory appeal and it divests you of no jurisdiction. In fact, there is a provision, and I was just going to pull it up, in the Nevada's rules of appellate procedure that allow you to make rulings, and if you think it conflicts with what's going on in the court of in the Supreme Court, then to get approval for the ruling or permission for the ruling from the Supreme Court, so you can go ahead on. Obviously, we have issues here, other issues besides that, the issue I appealed, and I don't think you're divested of jurisdiction at all.
Thank you for that. Mr. Ott, your thoughts, please.
So I disagree. I think that at the time of filing of a notice of appeal, divest the court of jurisdiction under Foster v. Dingwall, except with regard to matters collateral to the appealed order. Everything that the court was before the court was set forth in that July 22nd order. So I believe everything under that order was placed before the Supreme Court by plaintiff's appeal and then confirmed by the state's appeal later in the week. I also think that there's an issue of in light of the actions last night in the press conference last night from the governor, there may be grounds for a stay, even if this court does want to continue to have jurisdiction. But I know that the court asked to just talk about the jurisdictional issue, so I'll save that for another moment.
All right. Before I put a finer point on that discussion, Mr. Thierman, what else were you hoping the court would address at the opportunity of this status conference?
Well, the rules, I mean, I made I'm going to make a motion for a, in the Supreme Court for an emergency hearing or a expedited hearing.
Saw that.
And the rules require us to at least inform the court and perhaps maybe even discuss it, as well as to meet and confer with opposing counsel. Obviously, if the state wants to resolve this quickly, they would stipulate to an immediate hearing. I don't think I think it's all questions of law, not questions of fact.
Well, the meet and confer requirement, as I understand it, is to see if the issue that you're seeking for immediate relief on, that underlying issue could be resolved, not just singularly the issue of whether the state would agree to an expedited brief, or maybe both. But Mr. Thimron, do you think it's just the latter?
No, I think it's both, but I would be presumptuous for me to assume we're going to find, I mean, I'd love to, but I don't think we're going to find common ground on the underlying issue.
And not the underlying issue that you're seeking relief on. Does your analysis of that change in light of anything that may have happened in Carson City yesterday afternoon?
Not really. I mean, I'm hoping it will, but you know, the proof's in the pudding, and you know, 60, 90 days out, we may have a final resolution of this. Through the executive branch, I don't know, but I can't. I mean, you know, it's been 5 months, and people can't wait any longer. I mean, I wouldn't have taken the interim appeal if I thought we would, you know, if we could wait. That the whole point of this thing, it is urgent, and it's dramatic. It affects a lot of people. 5 months without pay. I don't know anybody here who would like to go 5 months without pay, and then another 3 months on top of that. They're talking about a 3-month time period. But if it resolves itself and moots my case out, I'm all for it. I want to see people get paid. That's what we're here for. That's what I'm here for.
Okay, but you're not withdrawing any part of the case, any part of the appeal, any part of the motion for expedited briefing in light of anything that happened in Carson
No,
City.
and I want to say something about that. Okay, that the court has, and I think that, and I hope the governor doesn't, but the court has gone back and looked at how we got here. And I keep saying how we got here is irrelevant, that we need systemic fixes. And I'm proposing a systemic fix based upon the law, not based upon any business meeting we're not having. You know, the law is in all these entitlement cases, whether it's Social Security, which you pay for, or whether it's a welfare, it's the essence of the entitlement that it becomes a property right at some time. And the whole system, and I was entering law school when Kelly v. Goldberg was decided, so I guess I have more gray hair than anybody else. That the whole system's geared on a quick determination and an appeal. And what we've got from DETA is this infinite do loop of reconsideration. They never make a determination that they're willing to stick with. And as a result, we've been going 5-6 months without resolution, and we get retroactive redeterminations. My point is, they made a resolution, whether it's on this, my issue on appeal or their issues on appeal, they made a resolution. Let's expedite the appeal process and get it over with. And you can't just keep re-examining it and putting people in limbo forever. That's not the way the system is supposed to work. That's not due process of law. So I applaud the governor if he's going to fix this, or his task force is going to fix it. I'm suggesting that the fix, at least for now, because we need immediate relief, is to go ahead and take them at their word that they granted these people approval and make them pay until such time as the ALJ says they can't. So it's not so much a difference in goal, it's a difference in how we get there. I hope the governor can do his work, or the governor's task force can do their work quickly and get there their way. You know, but this is the way I know, the way I was taught to get there legally, and not from a business point of view, but from a legal point of view. So no, it doesn't change anything.
Okay, Mr. Ott, anything a change in your analysis of the appeal rights of the state and the request for appellate review of the court's prior order because of anything that may have happened in the last day or two?
Not as to the jurisdictional issue, Your Honor. I believe that those are governed by the controlling case law in Nevada and the notices of appeal. I do think that the press conference yesterday, the appointment of Speaker Buckley, the appointment of an interim director, the message from the governor's office that they're prepared to devote substantial resources, and the mention of many of the issues that Special Master Granasso looked at, and I believe that this court has expressed interest in. I do believe that those are grounds for a stay, but if you don't want to be heard on, want me to go into that, I'm happy.
Well, I wasn't preparing for an oral motion for a stay. Really, I want to stay in my lane here. And right now, my lane is this: do either of the appeals or both divest this court of jurisdiction for all things other than collateral issues? And just so we're all clear, in the court's estimation, at a minimum, a collateral issue would be for the court to review, consider, and rule on an application for professional expenses from the special master. No matter how the court decides its jurisdiction here, that is still in play. All right, that being said, here's what I'm ordering. By Wednesday of next week, close of business, simultaneous short memoranda of law from each side that identify whether this court continues to have full jurisdiction or if either or both of the appeals has in any way affected the court's ability to preside on this case. Being informed of each side's position, having reviewed the briefs when received Wednesday, and I'll take them up as soon as the court can the following day, I'll issue an order. And I'll either confirm the court believes it may continue in all respects, or that the court may continue on some lesser than all respects, or the court believes it does no longer have jurisdiction to hear the material issues in this case, other than some residual pendent issues. Once that order goes out by this time next week, Mr. Ott, if the state believes it has a legal right to ask this court for a stay in light of new developments, then I would expect you to file a motion to that effect, give the plaintiffs an opportunity to respond, and then the state to reply and submit it. And I'll either set a hearing or I'll just rule on it. So I'm not going to entertain that right now. That's beyond what the scope of what I believe this hearing would be. With respect to Mr. Thurman's motion seeking an expedited ruling from the Supreme Court under the unique circumstances of what the appeal is about. In terms of discussing that, I'm not prepared, I'm not convinced that any of the court's prior rulings were erroneous or need to be amended or need to be withdrawn. So to the extent that we're using this opportunity to clarify that, the court does so now. Now, Mr. Thurman, let's go back though to the hearing that resulted in the writ of mandate being granted in part and denied in part. You and I had an exchange, and I asked if, the court's recollection is, I asked if you wanted a definitive ruling on the other portions that were not granted, because if you did, they were to be denied, and if you did not press the court for a definitive ruling, they would be, held in abeyance or essentially denied without prejudice. But if you want to clean things up, so you know exactly where the court stands on that, I could be moved to make more clear the court's prior view. I'm not encouraging you to do that, but if you believe that's in the best interest of your side, I'll entertain discussion on that now. With respect to the order to shorten time, I'm not the one that decides that it's such a pressing need on appellate review that it should jump over the myriad other important matters that appellate courts or the Nevada Supreme Court is reviewing. That's up for them to decide. But you certainly have convinced the court that this case is extraordinarily important, which is why you have essentially your concierge judge here waiting to meet with you as time allows, as soon as something important comes up like we're doing right now. All right, with that as background, Mr. Thurman, what else would you like to say or move or seek at this point?
I think your order is clear enough. I don't think it, I don't know what else you would say that you said it in your order. You obviously reserved the ability to make further rulings, and if you retain jurisdiction, you would have that ability anyway. You could do a judgment notwithstanding verdict, sponte. So it doesn't seem to me that your order in and of itself needs any cleaning up. I know at least exactly what, in terms of my issues, what you've decided. As far as the merits is concerned, I wasn't asking you to reconsider your merits. The question is, is this something that maybe it's better to put me out of my misery early, get this over with, and have the Nevada Supreme Court say, hell, we're not going to. We think the judge is absolutely right. There's no private right of action here. There's no reason to complain. You're lucky to have employment benefits after all. Whatever they say, I don't know, but resolution is better than not. And I think that there are enough people, and from the news articles I read, certainly in Las Vegas, there are enough people who are out of work, desperate. I get enough phone calls and emails of drastic circumstances that I think that it's worthy of expedited review. Obviously, there are lots of things on the Supreme Court's docket that are extremely important, or else they wouldn't be there.
Understood. Mr. Ott, would you like to be heard on that?
To Mr. Thierman, whether he wants you to issue the denial on the other issues. So
Well,
we can take it up in person.
he's sort of thinking out loud here. He said, maybe would ask the court to use his phrase, not mine, put him out of his misery, but there's no formal request. So I'm going to go with the first thing he said, which is, we're content from a legal procedural point of view with the way the order reads at this point.
To clarify, I was talking about the court, the Nevada Supreme Court putting me out of my misery on a quicker basis.
Oh, I see. Well, we'll see what they're going to do in response to the request you've made. Mr. Ott, would you like to put anything else on the record?
No, I think it's clear that we'll do briefs by Wednesday, and then if a motion for stay is needed, you'll entertain it after that point.
All right. Now, let's be clear. Thank you. And let's be clear on this. With respect to the prior orders of the court, they remain in place and they are of full force and effect, which means I'm fully expecting, and I'll hear from Mr. Guanasso in a minute, I'm fully expecting the special master to continue doing what the court charged him to do at this point, namely, one, to review, interact, and report back to the court on the state's progress to abide the court's writ of mandate, and also to inform the court as to progress being made on the other issues for which the writ has not formally issued, and if progress is seen to be made, may not be issued. On the other hand, if I get the sense that there's no good faith effort by the state to make progress, or if there are serious lapses in approach or judgment or direction, then I will certainly consider a renewed motion by Mr. Thierman to go further with the writ of mandate than the court previously did. Mr. Guanasso, how goes your efforts, and you think we're on track for the supplemental report that the court has asked for, and then the hearing, I believe, a day or two thereafter?
Yes, Your Honor. Thank you. Since you gave me the charge to work with the parties to ensure compliance with your prior order, I've met with both parties via a telephone conference to monitor the issues, to elicit some help in trying to identify the people who have not been paid and get those names and the information about those individuals to Detr. Our office created several databases in collaboration with Detr. Detr said that they needed the information in a certain format. We provided that to them, and that's allowed them to have a body of information that they can work with to cull through so that they can, identify what the court has asked them to comply with and begin to work through that backlog. As you know, Your Honor, though, from reading in the news, I'm sure the state has been active on its own initiative to work through the backlog and to comply with the court's orders through new legislation that they got unanimously approved through the legislature, and then through the establishment of this task force. And if you listen carefully to the comments yesterday from the governor and former Speaker Buckley, they've identified the precise issues that are before the court and appear to be working diligently to work through those. I've invited the plaintiff's counsel to provide information regarding the people who haven't been paid. And I think Mr. Thierman stated it right. He said that it's not a matter of not sharing the goal of getting people paid, it's how we get there. And Mr. Thierman has pointed to the people who have received eligibility determinations that haven't got paid. And so my invitation to him in collaboration with Detr was to provide the information of those claimants that fit into that category. They're all the information he has, so I could pass it on to Detr so that we could get those people through the system, and in an effort hopefully to have avoided these appeals. But I think that form of relief or that pathway to relief wasn't quick enough for the parties, which is fine. That's certainly their prerogative in terms of how they want to get relief for the people they're representing. But as far as being ready to have a report, I know working with Detr and working with plaintiffs counsel that we're on track, Your Honor, and we'll have something to you. One other thing I'd like to mention is that there is a group of people that share a lot of this information about how people are getting paid, what's happening with Detr from a claimant's perspective, that are represented in the Facebook group, the PUA Face group, and Amber Hansen has been a wealth of information in that regard and has helped us get data to Detr so that we can work through that backlog from a specific claimant standpoint, moving from generalities to specific claimants who have specific problems with the system. And Detr's been gracious enough to work with us to work on that portion of the backlog as represented by that group. So a lot of work's happening, and there is some progress being made, albeit I understand for those who haven't still not paid yet, that it's just not quick enough. But I think all of government is moving to address this. The court is, the legislature has, the governor's office has. This is a priority statewide. And so I expect my report will reflect that relative to your order, and that you'll see that substantial compliance has been achieved by the time you get my report.
Okay, well, thank you for the update. Mr. Thurman, hearkening on what Mr. Guanasso just said, I mean, it's unimpeachable that your case and your client's condition has the full attention of all three branches of government in the state of Nevada right now. The fact of the matter is, though, that I have a legal role here, a judicial role, and I need to stay in my lane. And my lane right now is to rule on the matters before me until and unless I believe either A, I have been divested of jurisdiction, or B, an appellate court tells me that I've been approaching it in an incorrect way, or C, I grant a motion to stay, and then I wait to see how things play out in other directions. But is there anything that Mr. Guanasso just said that you would like to comment upon?
No, he's using the same data source that we are, and we don't have the staff to. Well, I shouldn't say this, but I'm going to. It's strange that Detr doesn't have access to this information because they're the ones who put out the letters. But we'll make sure that all the PUA groups send their letters of acceptance/denial to Mr. Guanasso at his email address, and he can sort through them. I will note for the court's record that we have Detr is still sending out blanket rejections based upon claims for compensation prior to March 7th. Same language as before. Detr is still telling people that they've changed unilaterally. They're either the amounts of money or they stop paying them completely, as before. And I don't know what substantial compliance means, but and these also should be reported to Mr. Guanasso, and he can put it in his report. I am not questioning the good faith of Detr. I'm not questioning the good faith of anybody. I just have a different approach, and frankly, we all want the same things, but I want this. I'm trying to go off the legal syllogisms and try to get it, and maybe the smarter, wiser people will figure out another way of doing it quicker. I don't care. It's whatever gets it done best.
Okay,
quicker.
Thank you. Mr. Ott, any final comments here before we move off this and conclude this hearing?
Just a couple, Your Honor. We have received information from Special Master Guanasso, and there are people crunching those numbers as we speak. And thank you again to him for expediting some of that information so that we can get it as quickly as possible. If plaintiffs would like to,
Well, just to put it in perspective, I want the special master to assist the court. He's the court's special strike force, but he's expensive. And at the end of the day, he's going to be paid for his excellent services. But I'd like to transition him after we have the next hearing. I want to transition him to a point where we can let these things happen more organically. The courts, it's not lost on the court. There's some new senior administrators. I want to welcome the new administrator for Detr and wish her well in her task. And I want to, commend the other branches of government for doing what they're doing. Of course, it doesn't change the legal analysis here. It just changes whether the parties believe the best approach at this time is to continue to invoke the court's jurisdiction to move this case forward or not if I'm otherwise stayed. But the special master is working hard. He's doing what the court has asked him from the court's perspective. But I'm envisioning that hopefully we can wind down his direct interaction in the very near future so that the parties can save the resources that are going to have to be paid to compensate him properly, and he can move on to other things. So with that, I didn't mean to step on you, Mr. Ott. What else would you like the court to know?
No, well, I agree with the court. One of the things that I noted from the press conference yesterday was that Speaker Buckley and the other individuals would be volunteering their time. So to the extent that we're getting executive branch solutions to these issues, and those are going to come with a volunteer label without a price tag, I think that's an encouraging sign and very preferable. I guess what I was going to say was, to the extent that Mr. Thierman is alleging that he has a class, it would be helpful to get that information from him so that we could do the similar analysis that we're doing with the special master's information. But we will work with the information that we have, and to the extent that that information is not forthcoming from plaintiffs, we'll work with the information we have. One final point that I should have mentioned earlier: the court mentioned that it would like briefs on the jurisdictional issue. I didn't know if that intended a hard page limit or not. So if
well, I mean, let's shoot for 5 pages or less. It's what's the old saying? It's harder. It's easy to write a 20-page brief. It's a lot harder to write a 5 or 8-page brief and get your thoughts and arguments across. But let's shoot for 5 pages. I mean, this is not novel. We're not reinventing the wheel. It's a little bit of a unique case and it has a few nuances. It's a putative class, but they're not yet certified. It's a case that's up on an appeal of a mandate, with a request to expedite the briefing. So it's a little nuanced. I just want each side's thoughts because right now I'm not slowing down. But if I'm if I'm convinced that the court does no longer have authority to maintain jurisdiction over the substantive matters in this case, then I will, abide by that and issue an order to that effect. But until and unless that moment happens, then we continue. All right, and then I want to just recognize Administrator Gaw. I'm not trying to, ma'am, ignore you. Usually I don't call on people unless their lawyer, has no objection, because sometimes the lawyer is concerned, what might be said. But we've had a good, healthy dialogue in your other interactions with the court, and I very much appreciate you being here as a representative of the state of Nevada. All right, so that's how we're going to conclude this hearing. Briefs, no later than Wednesday, close of business. Let's try for 5 pages or less. Court will issue an order with respect to its belief on its continuing jurisdiction or not. Mr. Thierman, you can truthfully tell the appellate court that we discussed and are aware that the plaintiff/appellants will be seeking expedited review under the circumstances of this case. The court's orders, prior orders, remain in effect. The special master is on track. I've told you that even if the court believes it no longer has jurisdiction, believes it will retain some ancillary jurisdiction on things like compensation for the special master. I've indicated I'd like to wean us off of his excellent services at the earliest convenience. And by the way, Mr. Ott, the court was not aware that those officials that have been appointed and accepted appointments to be involved on behalf of the state, as communicated yesterday to the public, we're doing it apparently at no pay and out of the goodness of their heart to help the people of Nevada. If that's the case, that's remarkable and encouraged and commended. And even if it turns out that it's other than that, if they're still willing to assist on a compensation basis, well, it's still, in the court's estimation, a good sign that people of their stature and experience are going to be involved. All right, enough of that. Special Master Guanasso, anything else the court may have overlooked at this point?
With regard to jurisdiction, I should know, Your Honor, the only thing I was curious about with regard to the report is that there appeared as Detr fixes some problems, other problems seem to emerge. Like there were a series of denials that went out yesterday and today. And I'm wondering in my report how to handle some of the newer issues that have come up that weren't originally contemplated when we started on this.
You know what? I don't have a direct answer for that. Right now, the singular charge is to determine compliance with the order of mandate on those two buckets of folks, and to determine and report back the level of effort and movement and compliance to go forward on those other groups of people, which the court was not convinced an order of mandate should issue, but continues to have a level of concern. Now, if other things crop up as part of your interactions with these folks, if you can assist them in some way so it doesn't, this smolder doesn't burst into a flame, more power to you. But at this point, I would suggest that the vast majority of your time be on the issues that have already been brought to the court's attention. Mr. Rod, anything else before we conclude this hearing?
Your Honor.
Thank you. Ms. Jones, always nice to hear from you. Not that I don't like to hear from Mr. Thurman, but it's nice to hear from you too. Anything else the court may have overlooked?
No, you already addressed what Mr. Guanasso off topics. That would be the only thing I would have to add. So thank you.
You're welcome. Mr. Thurman, anything else before we conclude the hearing?
No, I'll just put out there that if there is a change in leadership at Detr and they want to discuss systemic solutions on as part of a settlement or maybe a consent decree or whatever, that gives them cover, or with the DOL, you know, they know.
Well, let me run with that just for a moment. If the parties believe that there is an opportunity to resolve the litigation piece here on ways that are acceptable to both sides, you know, I encourage dialogue, and I'll even bend the court rule here that I'm trying to keep Mr. Guanasso just to those specific topics that I've already identified and really not expand his scope, because I want to wean us off, as I've said. On the other hand, if you believe there's overlap of interest that might result in some or all of this case and the appeals being resolved, I encourage you to explore it. Now, I know that when you file a notice of appeal, normally you get a settlement judge who's trained often to help resolve Supreme Court appeals. Whether you get one in this case and whether he or she would be effective to assist, I don't know. But I do know that Mr. Guanasso knows a lot about this area. He's invested a lot of time. He knows the parties. He knows the issues. So if you want to use him as a resource, I certainly would encourage that if he's willing to do that, to try to assist the parties in resolving. But, you know, again, I'm trying to keep the cost of his involvement moderated, and only if both sides believe there's a good likelihood that he could assist the parties in resolving some or all of this case. All right, I'll leave it at that.
Your Honor, the Supreme Court already kicked us out of the settlement program.
Okay,
So
well,
we never got in there.
You never got in. Well, some cases they either determine on their own or based on what they're presented with that it might not be appropriate. But
right.
But having said that, all right. So thank you for sharing that. But Mr. Guanasso would be somebody that if I were on the other side of this call looking for a neutral who knows the material, knows the players, knows the law on this, and would be fair and neutral, he'd be on my very short list. That's one of the reasons he's been involved in this case from the beginning. Okay, enough editorializing by the court. I wish everyone a pleasant afternoon, a nice weekend. Thank you for working on your briefs. Believe me, I wanted to say Monday at a close of business, but I wanted to take pity on the fact that it's a summer weekend and I didn't want to be accused of cruel and unusual punishment. On the other hand, it's important to know each side's view of the court's jurisdiction, and a ruling will come out promptly, but don't let that knock us off stride pending that court's order. Let's move forward. to see if we can make some progress. With that, that will conclude this hearing and the court will go off record. Thank you very much, everyone. Have a nice weekend.
Yeah.